next person to rent that space, but you're not entitled to get the whole wall painted based upon this, mark or gouge or whatever it was. The repair should cost a lot less than $680.
I understand, and Helen expressed the same concern. She asked if we could split it down the middle, and I offered to actually cover anything above 500.
That you can't find a contractor willing to do it for less than $680 is a you problem. That's not a her problem. My job is to do what's fair and right at the end of the day.
Today we are going to witness a small claims case that instantly turns interesting. What starts as a simple dispute over a wall repair quickly shifts when the judge openly reveals he once donated to the Democratic Party involved in the case. Instead of avoiding it, he confronts it head-on and gives the landlord a choice. That transparency sets the tone. This isn't about politics, it's about fairness.
File 2500107SC, Allegan County Democratic Party versus a Balanced Commercial LLC. Our parties here. So first things first, I need to make sure that the parties that are here are able to answer for the parties that have filed. Ms. Goings, can you tell me what it is you do for Allegan County Democratic Party?
I'm the chair of the party.
All right. And then Mr. Hassan, what do you do for Balanced Commercial LLC?
I'm the owner.
All right. So the only other thing before we get started here is to explain. I think I did the math on this, Mr. Hassan. I want to say 2008. I wrote a check to Allegan County Democratic Party, the same business that Ms. Goings is here representing. So you can do two things with that. One is I can tell you that I feel comfortable hearing this case. You can tell me you're okay with me hearing this case, or you can say, I would like to have this go in front of someone else.
Well, that was interesting. I guess the judge has a pretty long memory, but then again, I think I would remember donating money to the Democratic Party.
Your Honor,
Now the foundation of the dispute is laid out clearly. Rent was paid, the lease ended, and $680 of a $750 deposit is being withheld for a wall gouge. Then comes the first major blow. The judge calmly states he would value the damage at just $100. In one sentence, the entire financial expectation flips. You can almost feel the momentum shift in the courtroom.
I trust your judgment.
All right.
I'm comfortable with
So
this.
then we can move on from that. Small claims means we're trying to do this without any attorneys. Right now, nobody is represented by counsel, and we are trying to do this without anything like a jury trial to have this decided right here now in front of me. But right now, we're about to get started and get this done in small claims. That's how the parties wish to proceed.
Yes.
That's
All right.
acceptable to me.
Then the first thing I'm going to do is swear you both in. Go ahead and raise your right hands. Do you swear or affirm any testimony that you give here today would be the truth, the whole truth, and nothing but the truth?
I swear.
Yes.
All right. So essentially this, I don't get too much information, but I have some basic information here. This is essentially more of a landlord-tenant situation. I saw the lease. The lease was just going to be 7 months at $750. So in other words, just a few preliminary questions. All the rent that was due was successfully paid. Is that correct?
Correct.
All right.
Yes.
There was a $750 security deposit. Do you still have that?
I do still have a portion of that. I have $680 of that. $70 was owed back and mailed back. The cash was not checked.
Okay.
The check was not cashed.
And so essentially what's happening here is you're saying that 680 is I should be keeping that out of security deposit for damages above and beyond normal wear and tear, and that's what you got it priced out at. And plaintiff is here saying, I think that number is too high. That's the back and forth, right? So I'm told, okay.
Yes.
So here's the issue with this. I sort of do this all the time, so I'm going to do it sort of quick. Tell you what I think, and then I'll give you both a chance to argue that. So it is what's above and beyond normal wear and tear. Right. The problem here is I do agree with plaintiff's remark that, in other words, you can have that sand it out and paint it over. It does not mean you get the whole wall painted. 680 is just way too high. I would probably give you $100 for this. All right. Now, since that's probably right around what the plaintiff was thinking is fair and reasonable, I'm probably pretty sure she's okay with that. I'm just gonna ask you, this is your opportunity to tell me why you think that's a mistake and I need to change my mind before we finish up here.
I shopped around for the lowest quote.
Now the landlord tries to justify himself with contractor quotes, $1,000 minimums and $680 as the lowest offer. But the judge cuts through the noise. He explains the difference between what a contractor charges and what damage is actually worth. Just because no one wants a small job doesn't mean the tenant funds a full repaint. This is where courtroom logic starts dismantling business reality.
I've spoken with CentraPro prior to receiving a quote from company ending with Brothers, and CentraPro refused to come out for anything less than $1,000, having seen the photos.
I agree. Do you have a handyman you work with your properties? See, that's the problem. What's fair is to what say, okay, so most property owners have a guy, right? And for your guy to come out and sand this and paint it, I mean, is nothing. It's less than 2 hours labor and practically nothing in materials. The problem is no third-party company wants to come out and do that kind of business. So what they're saying is, well, we'd come out, but not for that little penny ante stuff. We're gonna paint the whole wall. Problem is, you're entitled to make it look like it's in good shape for the next person to rent that space, but you're not entitled to get the whole wall painted based upon this mark or gouge or whatever it was. The repair should cost a lot less than $680. I say that because I'm not telling you that you're able to find an easy way to get this done for less than $680. What I'm telling you is for a landlord to come after a tenant or back and forth over damages after they leave the apartment, I see that a lot. So I have a real sort of natural sense to gauge what would be the fair amount for that. And the amount that you kept is just too high for this particular issue.
I understand, and Helen expressed the same concern. She asked if we could split it down the middle, and I offered to actually cover anything above 500. She did not want to do that, and
well, when you say cover anything above 500, do you mean cover essentially have her pay 180?
No, I was gonna send her a check back for 180 on top of the 70 that is.
Oh, you meant you would just
completely
charge her 500 for it.
Yes.
Okay.
I understand that the pricing I received was high even for me. And again, like the $1,000 one was there was no way I was gonna try and claim that this shouldn't be $1,000 repair.
Yeah.
But I wasn't able to get a price lower than 680, and I believe
I understand why you're here, but what I'm saying is at some point in time, you guys have a breakdown in the process. You need a third party to come in and say, bam, that's what I decide. And so essentially, and I'll explain how this works on appeal, but essentially what I would find is that essentially I would put the damages at 100. The problem is that meaning 100 is owed from plaintiff to defendant. Which means that realistically what.
Here's where the numbers become real. The judge calculates damages at $100, then adds filing costs the tenant paid just to get here. The math is slow, deliberate, and impossible to ignore. When he announces $643 must be returned, it's not dramatic, it's decisive. The landlord doesn't just lose a little, he loses nearly everything he tried to keep.
What needs to happen is some of that security deposit needs to go back to plaintiff. Problem is, because you guys couldn't agree on how to settle this, now the plaintiff, Allegan County Democratic Party, has spent certain monies out of pocket to get us here today. They had to pay a filing fee, they had to pay to have you served. That $63 is recoverable by them as the costs of this. So essentially would set the damages at 100, but cost at 63. And so essentially at the end of the day, I'm going to give you guys the number to sort of make this correct rather than what did I say, 63, right? And so you have 680 of their the security deposit, correct? Sir?
Yes, that is correct.
Yeah. So essentially to what my judgment here is that $643 of that would need to be sent back to plaintiff. All right. That would be my judgment in this case. That would make the numbers work out. If either of you don't understand how I got to that place, I can sort of do the weave for you.
If you don't mind.
Okay, so of that $750, really what I'm finding is you should have kept $100, meaning that you would owe $650 back to the plaintiff, right? Now, you already gave some money back to the plaintiff. You gave them back $70, right? Yeah. And then, so really you would only owe them $580, but they spent $63 to get here today, which they're able to recover. And so really what it is the amount of money at the end of the day to satisfy the judgment I just made that you're holding that rightfully belongs to the plaintiff is $643. Now, I'm going to send that judgment out to parties and you'll get a chance to see that. Either party has a right to say, I don't agree with what just happened there. I want to appeal this in front of the district court judges. Now, to appeal this, you must do two things. One is you must ask for that appeal within 7 days of today's date. That window of opportunity closes. And two, you must come in and do that as a written appeal. It's not good enough to just call up and say, yes, I want to go in front of the judges. Now, I'm saying the 643 because that's how everything sort of works out. Really, what I could have done is say that you only owe, in other words, I'm not saying you have to pay out of pocket. That 643 is because you're actually, I want to make sure I get this right, you're still holding on to money from a security deposit, right? So I certainly don't mean for this to cost you out of pocket. It's just that the lion's share of that money would be returned to plaintiff under this judgment. You understand that?
I can certainly figure out on my end how to get those out. That wouldn't be the issue. But if I may ask, so I reached out to 2 contractors. Lowest I've received was $680. How did we reach a value on this damage at $100?
Well, because that you can't find a contractor willing to do it for less than $680 is a you problem. That's not a her problem. The problem is, how much is this really worth? What should someone be charging you to paint over that after they sand it? About $100. That's the fair judgment. My job is to do what's fair and right at the end of the day. Just because you can't find a contractor to do it for less than $680 is not her problem. All right. Ma'am, did you want to say, I just saw you raise your hand. We're about done here, but I didn't want to cut you off if you have something to say.
No, the only thing I wanted to say to Adam was I asked him to come in to look at that. My husband's a union carpenter and drywall. It was his specialty, and he could have gotten it done for nothing, but he wouldn't allow me to come in to look at it.
And like I said, I don't mean to give you advice, Mr. Hassan, but when you're a landlord and when you're in real estate, it's a good idea to find a guy. And by that, I don't mean it can't be a girl, but I mean to find someone that's trustworthy for the little jobs, because the third party that you find in the yellow pages are never interested in the little jobs. But as a landlord, most of the jobs are little jobs. So that's usually how this resolves itself, short of having to come into small claims. But we're all set for today. I'm going to go ahead and release parties. You'll get a copy of the judgment in the mail. If you're looking to appeal, don't necessarily wait for your copy in the mail, because like I said, that 7 days is ticking. All right.
Thank you.
Thank you, Your Honor.
In the final moments, the landlord questions how the judge arrived at $100. The response is sharp and unforgettable. Contractor pricing is his problem, not the tenant's. The tenant even reveals the repair could have been done for free. The judge ends with practical advice. Every landlord needs a reliable go-to person for small fixes. Case closed, lesson delivered. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.